Well, it is a little intimidating, all that fine print, and we're going to begin a series of reports tonight about a subject we think many Americans don't know very much about. It's a series about the fine print in the contracts that we as consumers sign when we agree to buy thousands of products and services. When we sign contracts, as we all do for a credit card, for a bank loan, for a mortgage, for telephone service, when you send in a product warranty, that fine print often says that we are signing away our right to use the full extent of the law if we believe someone has violated the contract. As you'll see throughout the week, this is an issue that affects many Americans, whether they know it or not. A woman who bought a car and says she got a lemon.
I feel completely violated, and that's the only term that I can use to explain it. That had I known that that arbitration clause existed in the contract, I would not have signed it.
A woman who believes her mother died from neglect in an emergency room.
I didn't know anything about it, and the more I talk with people, they don't know about it.
Consumer advocate Joan Claybrook.
If you did a public survey, you would find that 99% of consumers are totally surprised that there's small print in there that doesn't allow them to go to court.
That's what the fine print says. You waive the right to go to court to resolve any disputes you might have about the product or service you bought. You have agreed to binding arbitration. This begins with the Federal Arbitration Act of 1925, which gave companies a quicker way to resolve disputes with each other. Instead of a judge or a jury deciding who was right or wrong, the companies agree to an arbitrator. In the 1980s and 90s, several courts ruled that arbitration should apply to individuals as well. Many consumer advocates say that when the arbitration is mandatory, the consumer has lost a fundamental right.
It's a take it or leave it contract. You either sign it or you don't get the job or the credit card or the bank account.
Binding arbitration is just that, except in very rare cases there is no appeal. Arbitrators don't have to explain their decisions. The American Arbitration Association, the oldest group that conducts arbitration, says for one thing, the law is a practical one.
An average consumer arbitration through our organization takes about 4.5 months. Typically in court, if you're not going through small claims court, you're talking about years.
The association also says there are guidelines to ensure fair play.
If the process is properly balanced, so it's really a level playing field, and neither side has an advantage, there will be times where either the business or the consumer or the employee will feel uncomfortable because they're on the losing end.
Joan Claybrook says there's another flaw in the system.
The process completely favors the corporation because the corporation does repeat business with the arbitration company, and if the company routinely finds in favor of consumers or gives large awards to consumers, they don't get used again.
The fine print about mandatory arbitration. Tomorrow, what you need to look for when you're buying a car. It is fine print again, and there is more on arbitration and fine print at abcnews.com. When we come back this evening, the government issues a warning about the risk of bird flu. And we are taking a closer look this week at the rights that many of us have no idea we are signing away when making agreements. Many automobile contracts require consumers to give up the right to sue in any dispute. The car makers have been adding these binding arbitration clauses to some of their contracts, and the fine print is now part of all financing agreements with Ford and Chrysler and leasing deals with Toyota. With more on this you didn't know, here's ABC's Brian Ross.
It was late at night at the Honda dealership in Woodbridge, Virginia, when Kelly Lloyd bought her car.
We had quite a few papers here to fill out,
including one in tiny print that has become more and more common in the auto business. Binding arbitration, taking away Lloyd's right to sue the dealer if anything was wrong with the car she was buying.
I had no idea that it was there on the page.
Only later, she says, did she learn her 2000 Honda Accord had been totaled in an accident by the previous owner. She says the car shakes uncontrollably. The car doors lock without warning. The sunroof doesn't work, and the airbag is malfunctioning.
It could come out at any time while you're driving.
But that binding arbitration clause in tiny print meant Kelly Lloyd could not take her case to court.
It's just simply unfair that people who have legitimate grievances are not able to go to court because of an arbitration clause that they unknowingly have signed.
Instead, Kelly Lloyd's case and others like it are being decided by private companies, such as the National Arbitration Forum, NAF, of suburban Minneapolis. It hires its own judges and advertises to companies, including car dealers, that the arbitration proceedings will be kept private. The outcomes will be predictable and will mean a stop to million-dollar lawsuits.
You don't think advertising this as the alternative to the million-dollar lawsuit suggests you have a pro-corporate point of view here?
Nope.
Not at all?
No. I think everybody benefits from saving litigation costs.
But when we showed NAF Managing Director Ed Anderson the contracts consumers are being given to sign,
Let me get my glasses.
he too had a hard time reading the tiny print about arbitration.
Do you think that is fair? Isn't that pulling a fast one?
Oh, I don't think that's pulling a fast one at all, although it's not really my judgment.
But in the judgment of a growing number of car dealers, including this one in Akron, Ohio, the arbitration clauses are entirely fair.
It's a quick, fast way for us and a consumer to settle the conflict.
While most courts have upheld the arbitration clauses, one customer, Lisa Eagle of Akron, Ohio, was able to get out of it in a dispute over a new car she claims turned into a lemon.
I don't think that any consumer would knowingly waive their right to a jury trial as opposed to arbitration.
A state appeals court agreed, calling the arbitration clause she signed unconscionable. It's now so tricky that the head of the arbitration company we talked with suggests that people buying a car should hire a lawyer before they sign any auto sales contract. Peter, for car buyers, it's truly buyer beware of the fine print.
Very much so, Brian. Many thanks. And tomorrow we're going to take a look at the fine print in health insurance policies that actually prevent you from suing your doctor. When we come back this evening, the scheme to sell counterfeit Botox. All week we have been taking a closer look at the fine print, the rights that many of us do not realize we sign away in agreements for everything from cars to credit cards. Today in Washington, consumer groups launched an education campaign about this. We're going to focus tonight on the fine print in health care. Managed care plans and agreements for hospital and nursing home care often contain clauses prohibiting patients from suing when something goes wrong. Disputes must be sent to binding arbitration. This comes as a shock to consumers who think they might get a better deal from a jury. Here's ABC's Dean Reynolds.
2 years ago, 66-year-old Clorinda Mesa of Los Angeles went to the emergency room after hitting her head in a fall. She was treated and released the same day.
She had some complaints and we had some concerns, but they assured us that she was okay. We took her home.
4 days later, Mrs. Mesa died from internal bleeding that her daughter says doctors should have detected. But when she tried to take them to court, a binding arbitration clause in her mother's health care coverage blocked it. Waiving the right to a trial by jury, it was a clause she knew nothing about.
It bound the whole family. So we won't get our day in court, and yeah, I'm angry.
Millions of Americans are governed by such clauses, but medical professionals say arbitration is nothing to be angry about.
The more money we spend on legal process, the less money we have to spend on patients.
It's hard to say for sure that arbitration is cheaper than a trial. The process is secret, after all. But it's pretty clear that healthcare providers would oppose it if arbitration awards cost them more than a trial. They say the patients are the ones who would suffer most without arbitration.
I think that it's reasonable and fair, and it keeps the costs down, and it gets these things handled much more quickly. And I think those are all advantages to the person who may be injured.
The healthcare industry also prefers arbitration over trials because the life and death emotions at play before a jury in a courtroom are largely absent before an arbitrator in a conference room.
Doctors say reputations can be unfairly maligned in open court, but the secrecy of arbitration keeps many malpractice cases from public view. The doctor who delivered 3-year-old Naomi Franco is accused of malpractice by her parents. Deprived of oxygen at birth, she has cerebral palsy, is mentally impaired, and will need special care as long as she lives.
Can she walk?
No, she can't.
Can she talk?
No, she can't.
Can she see?
Very, very little.
Can she hear?
Through one ear.
But an arbitration clause in her grandfather's health insurance plan assures that a jury will never hear Naomi's case.
She's been denied her fundamental constitutional right to trial by jury because her grandfather happens to get health care from a big corporation. That's not America. Or I hope it's not America.
A lone arbitrator will hear Naomi's story in May. Dean Reynolds, ABC News, Los Angeles.
We have one more in this series tomorrow night, and you can find the text of all our reports in the series at abcnews.com. When we come back this evening, quite a show at the Space Agency today, trying to show that the shuttle is ready to fly again. For the last several nights on the broadcast, we have been focused on a process between millions of consumers and many, many businesses in the country. It is called mandatory binding arbitration. It is unregulated and it is final. And tonight we take a closer look at the arbitrators themselves. As ABC's Betsy Stark reports, many of them have concerns about whether the process is fair to consumers.
The spread of mandatory arbitration to so many corners of consumer life has been good for Lucy Barron.
There has been a phenomenal increase in this industry.
Barron owns one of the fastest growing arbitration and mediation companies in California.
ADR Services, this is Marie. How can I help you?
25 new cases a day, heard mostly by retired judges. At a going rate of $350 to $400 an hour, many times what they earned on the bench.
You don't have to be a retired judge to be an arbitrator, so...
You don't have to be a lawyer.
No. You can be anything.
Like most arbitrators we spoke to, retired Judge Robert Thomas has faith in his own fairness.
Okay, now this one isn't diagonal.
But he has doubts about a fundamental part of the arbitration process, lack of the right to appeal.
Have you ever had second thoughts about the fact that when it's over, it's over?
Sure. I had some tough cases where I kind of would wish that maybe somebody could have taken another look at it. Because it's a big responsibility deciding these cases.
Celeste Hammond is another arbitrator with serious reservations about the process.
They're giving up their right to a trial. They're giving up their right to an appeal.
She's disturbed by the secrecy of the hearings. She says she learned only by chance that a lender accused in one of her cases of fleecing a customer had been accused many times of the same abuse.
They're not open to the public. They're not open to the press. And then usually there's a confidentiality agreement between the parties not to disclose the outcome.
Lucy Barron says arbitrators don't write the rule book, they apply it.
Does it keep some things from coming to light, which should come to light?
Well, I'm certain that may happen. I'm certain it may happen. It's not our decision to make. It's made by the courts and it's made by the legislature.
One important point we should make here, the arbitrators we talk to endorse arbitration when people choose to settle their disputes that way, and it's between equal parties. It's when arbitration is involuntary between a consumer and a big company that they see problems, which of course is what we've been talking about all week.
Exactly, and it is that inequity that people have been so concerned about.
That's
Many
right.
thanks, Betsy Stark. When we come back,